I call to order the work session on the regarding the Turnagain Assessment District remand to the Anchorage Assembly. We'll begin by going around and making introductions of the people in attendance, starting with you, Mr. Flynn.
Patrick Flynn.
L.B. Gray-Jackson.
Tim Steele.
Dick Trainey. Adam Trombley.
Ernie Hall.
Paul Honeman.
Cheryl.
And I'm Cheryl Brooking. I've been retained as independent counsel for the Assembly, so I'm working directly for you. I don't have a dog in this fight. I'm your counsel. I've been working with Julia on putting together some information for you so that you know what's coming. I'm an attorney at Wilforth, Brecht, Cartledge, and Brooking, and I've been practicing municipal law for many years. I've done a lot of quasi-judicial hearings, serving as the attorney for the board as a neutral, and also as an advocate in front of different boards. So I'm coming to you with a little bit of experience under my belt. I'm not here to discuss the substance of the case, but I am here to discuss legal and procedural parameters and to give you information that will keep you out of trouble. One thing I do want to keep in mind is that I'm going to try to do this in an efficient, time-saving method. My style is rather direct and to the point. There's a lot of information here. Every sentence has meaning. I don't tend to babble on and on and on. So when you read these materials later at your leisure, every sentence means something. I don't have fluff in my stuff. The court, we'll be going through these materials here. I'm going to refer you first to tab 1. And the names have been highlighted. These are the parties that have engaged in litigation with the municipality. So you'll need to know who those people are in terms of between now and whenever the hearing is, understanding that you've got certain responsibilities with regard to ex parte communications and with regard to conflicts of interest. I also want to refer you to page 11, and this is the court's order, by the way. Page 11, there's a highlighted section in the middle of the page. Now, you're going to want to read the whole order, but I don't want to get into the substance, but that paragraph is the court's words, and that explains why we're all here today. This matter was remanded from the court back to the Assembly to hold a hearing using the procedures laid out in Municipal Code Chapter 3.60. And you're directed to, at that hearing, reassess the 3 improvement projects' costs under AMC 19.20.340. And Title 19 is your assessment district ordinances. Those are also attached here in your book, and you'll find those under tab 4. And that's probably the last time I'll even mention that, because again, I'm not getting into the substance, but I wanted you to have those ordinances with you.
Mr. Trainey.
What date do we have to have it back to the court? Do we have to take our action by a certain date?
Through the chair, one of the things we're going to be talking about is setting the hearing and the specific procedures for that hearing. A date has not yet been set.
Okay, thank you.
So you'll be reassessing the 3 improvement projects. There's 3 different assessment districts project costs, and whether the lift station project was improperly imposed upon the lot owners. And again, you're going to be hearing from lots more people on the substance of this, but those are the issues that you need to be aware of so that you're not talking to anybody about those things. And these are properties over in the Turnagain area.
Mr. Flynn.
Are we allowed to talk to each other about the facts as we learn them? Or as the sitting quasi-judicial body, or do we have to not talk to each other either?
Through the chair, you shouldn't be talking to anybody about anything until after the hearing. Or at the hearing, I should say. So, flipping back to the beginning here, I've given you a table of contents here right after the title page. And I want to go through, in summary, these materials. I'm not going to read all of this to you, but again, like I said earlier, there's a lot of detail in here, so please read it carefully at your leisure and give you a chance to absorb it. And if there are any particular questions, I can answer procedural questions as we go through here today, or else the Assembly Council or I can answer any particular procedural questions, but we won't be getting into substance. As you review this later, you may have further questions. Okay, so, in general, next page, page 1. As an elected governmental assembly, you have legislative authority and you have quasi-judicial authority. This matter falls under your quasi-judicial authority. You are going to be acting as judges in a matter that's presented to you. You are the impartial, unbiased decision makers, and you will be making your decision based on the arguments that are presented to you at the hearing. The hearing will be held publicly, but it's not a public hearing in the sense of what you're normally used to, where anybody from the public can come in and just give their say. This is going to be parties presenting to you. You're more like a court setting where you serve as the panel of judges. So there are procedures that will be followed. The next page, ex parte communications. Most of what I'm going to be talking about here is things to keep you out of trouble. Ex parte communications, that's the Latin phrase, are prohibited in a quasi-judicial context. The key thing to remember here is that when you're acting in a legislative role, you want to hear from your constituents. You want those communications, and you encourage those. That's lobbying. In this case, where you are going to be serving as an unbiased decision maker, you can't have information coming to you outside of the context of the hearing that could influence your decision. So what I've done here is described what they could be. 1 through 4 here, just some samples. Site visits, verbal conversation, it can be over the phone, in person, somebody sees you at the grocery store, written communications, emails.
Mrs. Gray Jackson.
Thank you, Mr. Chairman. Well, I have a question, okay? Because I'm friends with one of the colleagues, and I mean, I know better, we both know better than to talk about this issue, but we have a project, so we're going to be working with each other for the next 4 weeks, and I just want to make sure that that's not an issue, as long as we know not to talk about this, and we haven't, and we're not going to.
Through the chair, that's fine.
Okay.
You can talk to people about other things, you just can't talk to them about what's the subject matter of what's going to be coming before you.
Right, and I thought that, but I just wanted to be clear, because we're going to be working together for the next month, and I just want to make that clear, so that, I don't get myself in trouble. Okay,
If
thank
there
you.
are potential conflicts of interest, then those will be raised. Ex parte communications, and as well as other potential conflicts of interest, need to be raised at the beginning of the hearing. As soon as the chair opens the hearing, any potential conflicts or communications that could be problematic should be raised. Request a ruling from the chair, subject to being overturned by the rest of the body, and then you move forward.
But I'm just, I just want a little bit of clarity. I know that, we're friends and we have a project, okay, right now, and it's going to go through now until the election, all right? And we're not talking about this issue, we're talking about my project. So I just want to make sure that I'm fine, with continuing on with the project.
Through the chair, that in itself is not a conflict.
Thank you. Thank you, Mr.
That's
Chairman.
not a
Mr. Honeman.
To that light, there are some of us on the body that are at any time running for a campaign for office. Some of these people may or may not be contributors. What is that? Another just a disclosure, or is that something that should be returned or should be discouraged?
Through the chair, you have your conflict of interest ordinances, and after we talk about ex parte, we'll mention those a little bit here, and I've also included relevant portions of the Code of Ethics behind tab 2. So as with any other potential conflict, there are ways of seeking rulings, and you have an ethics board if you need to involve them on particular matters. I'm not prepared today to address
That question.
If you feel that you need a ruling on that, though, I would suggest that you follow your procedures laid out in your Code of Ethics if there's anything that could possibly disqualify you or could influence campaign issues. You want to make sure you're following the rules, absolutely. So you're raising a good question. I just don't have a specific answer for you right now.
Thank you.
So on the ex parte, subsection A here talks about what an ex parte communication is. Subsection B, what to do if you're getting a communication that you think is improper, or you get an email and you can tell from the subject line. Sometimes you can't tell from the subject line. You start reading it, immediately stop reading it. You can let the clerk know that you've got this, and don't read any further. Somebody starts to talk to you, you stop the conversation. If you don't, then subsection C on page 3 here talks about what the consequences of improper ex parte communications might be. These have come from various court cases that I didn't cite in here, but the worst case is that you throw the whole proceeding out and then you have to start all over and figure out who's going to be making the decision when the assembly is tainted. And so we try to avoid this so that we don't have that problem. And then on the bottom of page 3, I've described the rule of necessity, and I've included this. I've never had to use it, but it is out there. If enough people, and I've seen this actually happen, where people have attempted to taint the whole body. And the idea is that if you can't get a quorum, then maybe you're not going to have the decision maker, then you can delay the process. But the other side of that is that you're entitled to your day in court. You have a right to have a decision made. So if enough people are tainted, you have to decide anyway, and that's the rule of necessity. And I'll just quote part of this. Under the rule of necessity, a judge is not disqualified to try a case because of his personal interest in the matter at issue if there's no other judge available to hear and decide the case. So it could be a personal interest, a personal bias. If you end up with not enough people, you're going to have to, then your conflict no longer becomes a conflict, and you go with who you've got.
Okay.
The next-
I've seen you, but you're not allowed to participate in this. It's just strictly for the body.
The next section is a conflict of interest and ethical considerations. We've talked about this a bit. You've got several provisions that you're going to be bound by here. You're probably all familiar with your code of ethics anyway, but you have to have some sort of a conflict of interest code. It's required by state law. And you've already adopted procedures. If you feel you have a conflict, like I said before, you ask the chair for a ruling. That ruling is subject to being overturned by the remainder of the body, and that can be on an ex parte or one of your code of ethics questions if something comes up and you want a ruling on that. Title 29 requires every municipal government to adopt ordinances that prohibit conflicts of interest, and you've done that. You've gone beyond that, and you've got a much more detailed code of ethics. In addition to that, there's the common law, and that's not always laid out. And so I wanted to mention these because these are not always available. It's not going to show up in your code, but there's 3 that are usually implicated: the duty of care, the duty of loyalty, and the duty of obedience. The duty of care requires the exercise of reasonable care when making decisions as a member, which means show up, pay attention, do the best you can, and the parties are entitled to that. The duty of loyalty, requiring you to be faithful to the community and act in the best interests of the municipality, not for personal gain. And the duty of obedience prohibits you from speaking or acting contrary to the wishes of the body. That doesn't always kick in this type of a decision, except where you have maybe a split decision afterwards. It is not proper for a member of the decision-making body to then start actively trying to undermine the decision that the body has made. So those are the common law. I briefly summarized these. There is another one that your code specifically abrogates, and the only way to abrogate common law is for you to adopt an ordinance that specifically abrogates it. And one of them is in a quasi-judicial setting, that the court has held that there should not be an appearance of impropriety. In your code, in section 1.15.010E, and I've got this quoted here on the bottom of page 5, says that where the provisions of this chapter, which is your Code of Ethics 1.15, where the provisions of this chapter differ from the common law principle that an appearance of impropriety alone is sufficient to establish a conflict of interest or an ethical violation, the provisions of this chapter supersede the common law. So unless you've got something other than that, just the appearance of impropriety alone is not going to knock you off the panel or taint the process. Due process on page 6. I've described here the background for there's both federal and state procedural due process requirements, and in the court's order, the due process concerns are what, and I don't want to say what the judge was thinking, but it sounds, if you read the decision, the judge kicked it back because the judge felt that the procedures in AMC 3.60 are the ones that need to be followed in order to give the parties the constitutional due process rights that they're entitled to. So I've just kind of explained here, you understand what the due process is. They have a right to be heard, and they have procedures in your code that for quasi-judicial matters that need to be followed in this particular circumstance. On the next page, page 7, the decision and the written findings are absolutely critical. And I'm going to go through in more detail some of your code provisions about that. But you will hold your hearing, and then you'll hear from the parties, and we'll get into the specifics of that in a few minutes here. And then you deliberate, and then you issue your decision. A couple things I wanted to point out that are pretty important about this process. One of them is that after you hear all of the evidence and the testimony and the closing arguments are done, you can go into a closed session solely for the purpose of deliberations, and it is not subject to the Open Meetings Act. It doesn't have to be noticed. You don't have to open a meeting and then go into an executive session. It is simply not subject to the Open Meetings Act at all, and that's in state statute. So you can meet whenever it's convenient, as long as you don't talk about anything else. It's solely for the purpose of deliberating to reach a decision in this case. Then you issue your written decision. Now you will be assisted by independent counsel who will be present throughout the entire hearing process and will be assisting you in making rulings through the hearing, and will attend the deliberations and will assist you in preparing the written findings of fact and conclusions of law, and make sure that AMC 3.60 and other relevant legal procedures are adhered to. So you will have legal counsel, impartial, independent, not representing one of the parties. I've given you some guidance here from an Alaska Supreme Court decision. It starts kind of halfway through page 7. That talks about the importance of the written decision. And if your decision is based on facts in the record and testimony presented to you and within the confines of the law, then you've got a solid decision. It still could be appealed, you can't help that. But it's more likely to be upheld if you've got a reasonable decision and you've explained, you've linked the facts to the law, and you've laid out why you came to the conclusion that you came to, and it's based in the record. Okay, so now, I'm going through this fast here. I'd like you to flip to tab 3. These are the procedures that you have adopted in your code for quasi-judicial hearings. These are the procedures that you will be asked to comply with. And if you've got a pen with you, you can mark the ones that I think are probably the most important for you to pay attention to. In the table of contents here on the first page, 045, hearing procedures. 050, scope of review. 055, decisions. 065, ex parte contacts prohibited. 070, conflicts of interest. and 080, appeals from administrative decision. So let me hit a few of these. Flip the page there, and one that I didn't have you highlight is just one of the definitions. Right up on top it says a quasi-judicial proceeding means any hearing, formal conference, or other proceeding before a municipal board, commission, or official to review the legality, appropriateness, or wisdom of official actions taken on behalf of the municipality as they relate to the particular legal rights, privileges, duties, obligations, or remedies of identified individuals. And again, that's why we're here. You are being asked to determine the rights of particular individuals. And that's why it's not just a standard public hearing and legislative thing. This is, you're making decisions that affect particular people. So you're in a quasi-judicial mode. Okay, the next page, page 3 there, in section 045, the hearing procedures. I'm going to spend a minute on this because these are pretty important. Generally, these are conducted somewhat informally. Are we all there on 045 hearing procedures?
Mhm.
Okay. Now, right in the first part there, it says they may be governed by such rules and procedures as the official agency, board, or commission empowered to conduct such hearings or proceedings may choose to establish. After I go through this, I'm going to be proposing some specific rules that you adopt to supplement what you already have in 360. Okay, so you've got parties may appear in person or through counsel. In this situation, you have the municipality of Anchorage, and you've got parties that are named in the litigation. They are each represented by counsel, and they're also in this room. So it is up to them to be presenting to you their arguments, and it's up to them to do so efficiently and logically and clearly, and to point you to the evidence that they think is important for you to hear. And that's their job. They can present witnesses and evidence. They can cross-examine. And you can ask questions too. Now, we're not in the Alaska court system or the federal court system, so we are not bound by the formal rules of evidence. But you may hear, as the procedure goes by, particularly where folks are represented by counsel, objections to the admission of certain evidence. And that's because the courts have adopted rules of evidence that prevent improper, irrelevant, or hearsay evidence from coming before you, or certain testimony that, and I'm going to give you an example. You've got a hearsay evidence statement in here that you can consider hearsay evidence if there are guarantees of its trustworthiness and that it is more probative on the point for which it is offered than any other evidence which the proponent can procure by reasonable efforts. And let me just tell you what hearsay is. Some of you probably already know. I'll give you an example. I'm on the witness stand, and I testify that Julia saw a boat go by 2 o'clock yesterday. I didn't see the boat, and I'm not Julia. That's hearsay. So if I'm testifying for the fact that Julia saw a boat go by, that's hearsay, and normally that would be improper. So you're allowed to, in this context, ask, why isn't Julia here to testify about that? Or most likely it would be one of the attorneys objecting to that sort of thing. Or you can decide, well, we'll let it in, but we're going to decide how much weight to give that testimony. We'll decide whether it's really important or not. And with 2 lawyers in the room, you're going to have people on their toes. The proceedings, the hearing will be open to the public unless anybody objects. I'm imagining at this point it's going to be open to the public. They can bring in witnesses, documents. Now, there's some question here, and this is something that may need to be dealt with procedurally in advance on the production of documents. And the reason that I want to bring this one up is that there already is an administrative record. It's been to court. It's come back. The court has ordered the municipality to index the record. So Whether new evidence can come in at this point, I will leave that to the parties to discuss. And that may be something that you'll need to decide before the hearing. Whether you're going to limit this to the record that's already out there, or whether there's going to be some changes to it.
So with that, and that's probably one of my bigger concerns. If we're being tasked by the courts, they're remanding it to us to make decisions on what's in record, what's on file, just a better explanation or an opportunity for due process. Having new evidence reports that there's something that the court didn't get in the first place, which they may have been able to come to a ruling if they had such evidence. So I'm a little concerned about that. I don't know. Is that something that we get through Assembly Council? I suppose that it wouldn't be proper for the municipal attorney since they have someone presenting their side of the argument.
Through the chair, it's not, because the municipal attorney is representing party in this case, it's not appropriate to get advice from the municipal attorney. You can certainly get advice from the assembly attorney, and it may be something that you want to ask the parties to brief on before the hearing, whether there will or will not be, or what their arguments might be, and then you can decide whether or not you're going to let in anything new at this point. Because it has been a proceeding that's been going on for a while, but the reason it was kicked back is because the judge said that you should have followed these procedures, and it didn't happen. So, again, I don't want to get into the substance of it. I don't know if that's even an issue for them, whether they're going to stipulate to what the record is. I don't know. But I'm throwing that out as a question that I saw when I was going through this, because you've got procedures that allow things to come in at this type of a hearing. But in this circumstance, you've already got a record. So I'm just throwing that out as a question. I don't have an answer for you right now. I'm sorry, that's twice I haven't been able to answer questions. The hearing will be recorded, and the clerk or someone from the clerk's office will be present and recording the entire proceeding. We'll be swearing in the witnesses. On the next page, 050, the scope of review. This is something you're going to want to read over a few times, and you'll probably be hearing from counsel as to what they think your scope of review actually is. They're going to be trying to focus you on what's important to them and give you guidelines on your decision-making authority. Your decision in 055, this is an amazingly tight time frame. You have 15 days following the hearing to issue a written decision. That's really tight. So keep that in mind when you're setting your hearing date. And again, we're going to talk about the detailed procedures here in a moment. But at the end of this talks about, like I said before, the importance of the written decision. And this is actually a really good ordinance, so kudos to whoever wrote this section here. A clear and precise understanding of the reasons for the decision. I mean, this is really important. And also the last sentence, the final appealable decision must indicate that it is a final order and that a party disputing the decision has 30 days to appeal. And that appeal is also found in 080. But you have to actually tell them that it's final and they have a right to appeal to the Alaska Superior Court. And the Alaska Supreme Court has said you have to do that. 065, ex parte contacts are prohibited. They're expressly prohibited here in your code, and I've given you more detailed information and materials that we talked about a minute ago on what they are and what the procedures are, etc. If something happens. And again, conflicts of interest in 070, you've got a financial conflict of interest potential. Member of the family could profit in any way, and also your code of ethics. Okay, so that was AMC 360 in a whirlwind. We're going to skip over tab 4, but I would encourage you to read those at your leisure. to understand what your code says about special assessments. Tab 5 is a draft assembly memorandum that would set specifics for this particular hearing. And attached to that would be specific quasi-judicial hearing procedures that I've come up with based on my experience, kind of help lead you through the details of the process. So on the assembly memorandum itself, that action would adopt the proceedings, would set a date, or in this case, you're probably going to need 2 days because you may have quite a few witnesses and some material to go through. Some quasi-judicial hearings, each side gets 10 minutes and you're done. This one is going to be a little more complicated than that. It's going to take you some time. I have not talked to counsel, but this is something that they might want some input in on how long it's going to take. And again, these are my guesses. I'm guessing 2 days, back to back, 6 hours each day, to go through all of it, to allow for opening arguments, closing arguments, cross-examining, rebuttal, to give each of you a chance to question any of the witnesses on any relevant matters. This would also set a date, in addition to setting the date and the time for hearing, set a date for receiving briefs from the parties. And I've suggested a page limit so that you can encourage them to focus on what's important. And also, after that, obtain a brief from independent counsel.
Mr. Honman?
I didn't interrupt, I just want to give you a cue. Since we all know, I believe we have some municipal attorney apparently from the plan side, or call side. Is there, at what point do we ask or request of the parties how much time to expect? You're guessing 2 days, perhaps 3 days. I know in some cases there may or may not be an issue where we're available as a body. So you probably want to know in preparation for planning a date that you think the template looks really good. But is it 2 days? Is it 3 days? 6 hours? Each day? I don't know. I mean, at what point do we ask or solicit that information?
Well, what I would hope to do, and actually I did try to call both of them and just got their voicemail. I didn't leave any voice messages, but my suggestion is that as your attorney, that I meet with them together. I would not meet with either one of them or talk to either one of them independently, but just to talk about the procedural issues and how much time they think it would be, and to find out what days would be available for them, and then we can work with the clerk's office and with the chair to see if those dates would work. If you have some particular dates that you'd like to throw out, or ones that you know are not going to work, I'm looking at May or June. I know you've got an election coming up, so
Yeah. Mr.
this is a
Trainee?
little bit up in the air.
Anytime after the election, ma'am.
That's what I figured.
We're not doing
Yeah.
anything until that election's over with.
That's what I thought. So that's why I'm looking at May or June.
Yeah, and it would be my inclination, just conversation here, in all probability, there's going to be some new assembly members. I think it's appropriate to give them a little bit of time to get their feet underneath them, just as let them go.
Maybe we should
We
put this
got to
notice
set the
out.
bill levy right after they get in. We may as well make them
Do this too.
Maybe we should put this notice out
Give
before
them the full
probably very
degree.
close. They might have withdrawn from running.
Yeah.
I have a question that you could probably answer. Mine shouldn't be too complicated, I don't think. On the ex parte communication, under 360065, I'll just kind of read a little bit into it. No member, board, commission, or official receive otherwise engage ex parte communication from the applicant or appellant, applicant or other parties adversely affected by the appeal or application, or members of the public concerning the appeal or application of issues specifically presented in the notice of appeal. So basically, as anybody involved in the case, but also anybody who's not involved in the case, we can't talk about it. But that only talks about in regards to the appeal. I'm wondering why it only talks about that in regards to the appeal as far as ex parte communication, because I don't see anything of. Is there a specific reason as to why it discusses appeal? And the second part of my question is, it looks like I can't talk to anybody about this, even if they have no dog in the fight. Would that be correct? For example, if I have a brother in Minnesota. Oh yeah, we're going to be acting as I don't know why this conversation ever come up, but can I talk to my brother in Minnesota, if that were the case, about it? Or is that completely eliminated as well?
Through the chair, the first question is that, why is this when it's an appeal? This is an appeal. There have been decisions made with regard to assessments. Those are being appealed. So that's why it's considered an appeal of an administrative decision. And you're serving as the court to hear that appeal. And then the second part of the question has to do with speaking to other people who are not parties. If you're going to have a conversation with someone who could influence your decision making, then I would discourage that. If you want to just bounce ideas off of somebody, until you hear the evidence, you shouldn't be discussing it with anyone really, because you don't want to come into the hearing with any preconceived notions at all.
Yeah.
So that everybody comes in and you're a blank slate, fair and impartial panel.
Mr. Gray Jackson?
Thank you, Mr. Chairman. Did I hear you say earlier that we can't even talk about it amongst each other? Did I hear you say that?
You can do that in deliberations all you want.
Right,
That's
but
all
not,
completely
but not before.
confidential.
Right.
Right.
Yeah, so I don't plan to talk about it with anybody, frankly.
And when you do talk about it in deliberations, that is confidential.
Right.
And that's
Oh, yeah.
not recorded, it's not, and I would say treat it confidential, and your attorney will be there, it's attorney-client privilege.
Right.
Yes.
And if I may, Mr. Chairman, just one other comment. I am just really, really grateful to you for presenting this to us and letting us know what, how it's gonna work. Because, I had no idea this is gonna be my first time doing anything like this, even though I've been around for many, many, many years. So I really appreciate you going through this in this booklet. And I can guarantee I'll be reading all of it. And then I'm just a little bit concerned about, because this is real serious stuff, our four assembly members who aren't here today, who may be part of this, and because I think they need to get some instruction too.
My direction to the clerk and to the assembly attorney is the 4 books that are over there are to be picked up from the attorney, and they're to be given a briefing on this.
Great,
It's
great.
imperative
Great.
that they do that.
Thank you, Mr. Chairman.
We could go back to, Mr. Chair.
Yes.
Also, could the clerk's office have at least 1, maybe 2 extra copies so that we can make sure that those are part of the new assembly? And we know we're going to have at least 1 new assembly member, and we need to have that part of a packet for the new assembly members.
I think Ms. Tucker's got several copies there, but we'll make sure, because that is going to be necessary.
I came with 20 copies today. If you need more, just let me know. We can print more.
Thank you. I'm assuming these aren't copyrighted, so if we needed to, we could make copies.
Do that all you want, yeah, and it's a public document. Now, the quasi-judicial procedures at the end, I wanted to kind of go through these a little bit. This kind of lays out how you go through the hearing. And this is where, this supplements the procedures in 360. So the chair opens the hearing, the clerk will swear in. If you swear in all the witnesses at once, it just makes it a whole lot more efficient. If somebody else comes in as a rebuttal witness that hasn't been sworn in, the clerk will probably realize that and will let you know that that witness needs to be sworn in before they can testify. But if you do everybody at once and you get all their names on the record, then it just makes everything go a little faster. They all stand up together and get sworn in. So the clerk will be recording the procedures. and keeping track of the time, because I strongly recommend that you set some time limits. I've put in some sample time limits here, and these are subject to agreement by all of you, and I would recommend with some input from the parties' counsel. Opening arguments, for example, I put in 20 minutes. If they think they can do it in 10, bonus. That is to allow, in this case, the attorneys to present the case and kind of summarize what you're going to be hearing and what the issues are and what they think your role is, so that they're going to be laying out their case for you, summarizing things. I've identified the counsel of record here for you. Then you start with the presentation of the case. You start with the appellant, they present their case, and then the administration presents their case. You've got, I put in 90 minutes, could be more, could be less. When you have 90 minutes, it's kind of like a football game where that 1 hour can go on for several because you stop the clock a lot. For example, you have the witnesses testify, and that's the direct case. Okay, then you're going to have cross-examination by the other party. Well, the clock is going to stop for that. And then there's a time for everybody on the assembly to ask questions, and the clock's not running for that. Okay, so the first 15 minutes just took 45, for example. The cross-examination should be limited to the testimony that was provided in the direct, and it's to cross-examine them on the testimony that they've just given them. Now, when you as an assembly get to question them, judges aren't bound by that really. You can ask them whatever you want, but try to keep it relevant to the appeal subject matter. And then there's time for the rebuttal side, and each party puts on their rebuttal case. And so the way I've proposed this is that the appellants give their, put on all their witness, here's how it would go. The appellant puts on a witness. That witness is then cross-examined by the municipal attorney's office and then questioned by the assembly. The appellant then puts on their next witness, and they're going to be citing to evidence and same thing. Cross-examination and then questions from the assembly. And they go through this until they're done with their witnesses. Then the municipality comes on with their case, and they're going to present their evidence and testimony. So they put on their witness, and then the appellant's attorney gets to cross-examine them, and then you get to question the witness. Next witness, same thing. So that's the direct. Then we go into the rebuttal, and then you bring on rebuttal witnesses, and it could be different people, it could be the same people, but it's going to rebut the testimony that you've just heard, and each party gets their turn to do that with cross-examination, and more questions is from the assembly. Then take a little break. There may be more breaks in here, but take a break after the close of the evidence to give the attorneys time to finalize their closing arguments, and then give them, I put in here 20 minutes to tell you what you just heard and summarize the evidence that they want you to focus on. They're going to be making their arguments based on what was presented. It's not the time to bring in anything new. Then you can recess to a date and time no more than 15 days after the hearing. I want to talk a little bit about this. If you recess to a time when you can come back and vote on your decision, you're not adjourning the meeting. You're announcing when that same meeting is going to continue, so you don't have to go through your Open Meetings Act and noticing up a new meeting. You're still in the same meeting. You recess to a date and time certain, and you continue that same meeting. And it has to be within 15 days because you have to vote on and adopt that written decision. During that 15 days, that's when you have your confidential deliberations.
Mr. Trainee?
Question for you, ma'am. In executive session, we can't keep notes. Can we keep notes in this process so that we can use that when we're in the deliberation process? Because we go into executive session, we can't keep notes on anything. My question to you is this different enough that we can take notes as judges do? Can we do the same thing so that we're in deliberations? Refresh our memory on what we heard?
Through the chair, I would say that you almost have to.
Okay,
Yeah,
thank you.
because you're gonna wanna keep yourself organized. As to what happens to those notes later, I'll defer to the assembly attorney on that. But I think you're gonna have to.
Okay, thank you.
You're gonna have, who testified, what they said, what the evidence in the record, you're gonna wanna refer back to that later during your deliberations, and really that's the only way to do it.
Mr. Hardeman and then Mr. Flint.
So I know we can't talk or deliberate or until the hearing and after that. Can we at least talk in advance about, these processes, dates and things like that without being in any issue? We can talk about that. I think it's gonna take 3 days, well, it's probably gonna take 4. Or instead of 20 minutes, let's give them 30. Instead of 90, let's make we talk about the process and not be in issue.
Absolutely. Yeah, as long as it's procedural only, yeah, just don't get into any of the substantive issues at all. So, and those are the conversations that I've had with the chair, is just dates, times, when can we do this work session, that sort of thing. It's just strictly procedural. I haven't even seen the record.
I'm thinking about how we normally work, and it'll ultimately be up to the chair, whoever that happens to be when we hear this, as to how we proceed. What I can conceive of us deciding is we have our hearing, we recess to a date certain, we go into deliberations for a couple hours, we come up with what we think where we think we want to go, and then the chair designates 1 or 2 people to promulgate the written decision for the body to vote on when we reconvene. First off, can that assignment be delegated? And secondly, presuming it is, under what circumstances can we circulate that draft decision prior to the returning to reconvening, 14, 15 days hence?
That's a good question. You will have independent counsel who will be working with you and attending those deliberations, and can be drafting the decision based on comments made. But you won't be voting on that decision until you come back into an open session.
Right.
So that decision will be written and can be discussed amongst all of you throughout those deliberations. Again, you've got a really tight time frame.
Yeah, but my point is, I don't foresee us getting together every other day and talk about this. I see us getting together for a
Probably
period
a
of
single
hours,
session.
and then that written document gets started, with council's help, and then we start circulating amongst one another. Does this sound like what we talked about?
And those are confidential deliberations.
But I don't see us doing it together in the room. I see us, let's say Ernie's still chair and he says, hey, Paul, I want you to be in charge of working with Julia to get this produced, and then get it to us for review so we can get our comments in. Paul produces it, sends an email to the assembly members and said, here's what we've come up with. Does that sound like what we talked about when we were all together? Is that an appropriate way to deliberate, or do we have to get back together to discuss a written document every time we draft it?
You don't have to meet in person. I would suggest that you communicate with your attorney on an attorney-client privileged basis with regard to that written decision.
In other words, if you
you're
have somebody really in
assembly
charge,
counsel.
have counsel be the one in charge of distributing and collecting comments.
Yeah, and then your attorney then would be the one taking all of these different opinions and comments and incorporating them into a document that hopefully would reflect everyone's intent. But again, the actual vote on it would occur at a public session. But those emails are part of the deliberations, and in this context, that's allowed. And those are confidential attorney-client privileged communications.
Mr. Gray Jackson?
Thank you, Mr. Chairman. I think you may have answered my question, because I'm hearing that this does not fall under the Open Meetings Act, so we don't have to worry about notices and all that. And then I'm hearing open session. So while we're in not deliberations, when we're at the hearing, is that public? Is the hearing public?
The hearing itself is public. The
Okay.
deliberations are not.
Right,
And
okay.
then when you when you will recess after the hearing to a date and time certain and come back, that will be a public session where you will publicly vote to adopt your written decision, vote whether or not to adopt it, make any last minute changes at that meeting. So that document at that point will be a public
Right.
document.
I
So,
get
you
it
know, it
now.
is subject to amendment at your meeting when you're adopting it.
Kind of like a tryout for the jury. You know, I get it.
Yes,
Yeah.
yes. Yeah,
Yeah,
exactly.
thank you.
It's a
Thank you,
trial.
Mr. Chairman, yeah.
Okay, I've covered an awful lot of stuff here, but I covered it all, so I guess I would ask, maybe I'm just going to assume then that I will communicate with council about dates and times, if you have any information on dates and times that we can
Yeah.
help you set up the hearing date.
Okay,
That would be helpful.
I was asked to make those decisions, and I decided I'd rather have the body make that decision. I was first approached, it's just been a really long day, and I was wondering, I think we'd much rather do that in 2 different evenings. That's a long time to sit and listen. My preference, if I were picking, I would pick May, so we can get it. That will give new assembly members time to get in, go through with Julia the orientation on ex parte and what their responsibilities are. So I'd really like for us to kind of set direction for Ms. Brookings, so as she's meeting with the other parties, we've got some direction to work with. Mr. Horniman?
2 things. One is, to the indulgence and disclosure to the body, I intend on being in a conference later April, early May, so my preference is suggested would be no earlier than mid-May.
I think that would be good timing as far as I'm concerned. I'd just like to get this thing wrapped up toward the end of the month, if we possibly can. Is everybody else okay with that, Mr. Trini?
Mid-May works for me.
Mid-May?
Yeah.
Madam Clerk?
I'm going to caution you, too far in mid-May means that your 15 days is going to be Memorial Day-ish. So you want to just be cautious on your back end as well.
Right. I guess my response to that is to get the hearing. If we didn't get the decision done till after the first of the month in June, I don't know that that would be an issue. Ms. Tucker?
Oh, just to remind Bonnie, as Ms. Brookings has stated, it's a mandatory 15-day period.
Mm-hmm.
So you need to make sure that and I think that what Barbara was suggesting is that if you don't want to have it turn up on Memorial Day
True.
weekend, then to schedule it later in May.
Yeah.
And come back in June. When you hit mid-May, you don't have the leeway.
Right.
So to be safe to hit the timelines, we're probably looking at doing this the second week in May. Are you back by that time?
I anticipate yes.
Mr. Chairman, you do the week of May 5th or week of May 19th. If you do it the week of the 12th, we're landing, we're going to have Memorial Day right in the middle of right toward the conclusion of our deliberations.
Well, I'm out of town the 7th through the 10th of May.
One thing I'd like to say on the 15 days, and please correct me if there's something in your code that says differently, but normally if a deadline ends on a weekend or a holiday, the date moves to the next business day. So that's just something to keep in mind.
Nevertheless, we really don't want to spend her Memorial Day
Exactly.
writing.
Exactly. I hear you.
So the week of the 19th, no earlier than the week of the 19th, that would get us past that.
That would throw us, date-wise, that would probably work, because then we'll be far enough into June that the
Right.
Memorial Day weekend wouldn't be an issue.
Right.
But what I'm also suggesting is that since you have to adopt your decision on the record, then you're going to be having an extra meeting in June. I just want to make sure most
Mhm.
people don't do extra stuff in June, July, and August. So if you did want to finish it in May, then, as Mr. Flynn said, that second week of May would be one of your goal dates.
Yeah, but Mr. Flynn isn't available.
Oh, I must have misunderstood
No.
that.
Well, I'm not
It
available.
was,
Well, I'm gone.
did I
the 17th.
misunderstood you, Mr. Flynn? I thought there was a time in May that you weren't going to be available.
No, I just said that if you wanna do it, you wanna do it the week of the 5th or the week of the 19th.
And
Oh,
I said,
got it.
I followed up.
I
with-
misunderstood you.
And I'm sorry, Mr. Chairman,
Yeah.
I followed up with, I'm out of town the 7th through the 10th, I think.
Okay.
Maybe May 5 and 6 would be.
So, yeah, whatever, just, you know.
Back on May 5th?
I think that's pushing.
And we don't know about the other folks
Okay.
around here, you know?
Ms. Tucker?
I guess
Other
then
people aren't even
I would be
working.
concerned about having
I
part of
know.
your 15 days taken up in holiday.
Mhm.
And so you may want to rethink about scheduling it to
Right.
begin,
In
no,
June.
I was going to say the opposite, that have it late and start the very last part of April so that you could get things.
If we do the last part of April, I'll probably be out of town. I mean, I'm gonna be out of town the 7th through the 10th, and that, you know, that's not gonna work. Not for me.
Conference starts April 29th, too.
Yeah.
How about June?
Mr. Chairman, just pick a date. It won't matter. Somebody's gonna be gone.
I couldn't agree with you more, Mr. Flynn.
We'll make it work somehow.
we will get a date selected. We're gonna do it in May. We'll get a date set and established. Ms. Brooking, when you get done meeting with the others, just get back with us and we'll sit down and put a time on the calendar.
I can do that, Mr. Chairman.
And
Thank you.
Mr. Chairman, one last comment or question.
Yes, sir.
And that is it Ms. Brooking that we're meeting with parties to find out if there's going to be potentially new evidence and perhaps how many other witnesses in addition to what we see on the phone? I mean, is that the proper forum, or do we ask the clerk's office or send the council?
Through the chair, I'd be happy to do that. I am working with you through April 10th, so any kind of procedural issues between now and then, I'm at your service, and I'd be happy to do that.
Okay, thank you.
Thank
Ms.
you, Mr.
Gray
Chairman.
Jackson.
Just one last comment in terms of the date, okay? And like Patrick said, you know, somebody may not be able to make it. And that means that if that person can't make it for the first part, then they're probably excused for the whole thing, correct? Yeah, so just a point to
Mhm.
make.
Yes. Okay. Anything else? We're adjourned.